A very good afternoon, good evening, or good morning to everyone. It's a pleasure to be moderating this session today, and I'm so delighted that we have a very large number of registrations. I'm told at last count it was 477. So thank you so much for joining us in such large number. And many of you who actually might have been on the panel that we had 2 days back, I'm sure is really very exciting to see that we have a competing number on a seminar which is happening just about 2 days down the line from what we had earlier this week. For those who are not very familiar with the IIII, I'll just take 30 seconds to introduce. It's one of the premier global international federation of insolvency professionals, academics, judges, and other professionals. It is an organization which has memberships which comes in only by invitation and has played a very important role in global policy making, international benchmarking, global standard setting. We're so delighted that IIII is today actively engaging in the Indian market to provide the resources to the Indian insolvency professionals and other stakeholders. And this series is a part of collaboration that we have with the Indian Insolvency and Bankruptcy Board of India, with which we are very honored and pleased to engage with in order to provide and support the efforts of the Indian regulator in educational and learning of the insolvency professionals and other stakeholders. We've had 2 earlier seminars, and one of them, of course, was on this subject on avoidance. And I just wanted to underline the importance of the topics that we select. We all are familiar that over the last 4.5 years, there has been a tremendous amount of effort by the various stakeholders, organizations, representative organizations, and also something which IBBI has championed in a very energetic way, is to educate the insolvency professionals on an ongoing basis, on a continuous basis. What we realize in the recent times is that that avoidance actions is one area which sort of continues to remain a bit unattended by the insolvency professionals in particular. And even if it is attended, it has not received that kind of traction or priority in the market. Also, we haven't really seen too much of orders from the bankruptcy court on this. And even the jurisprudence on this has been a bit slow. And we thought that it is time to push this particular topic at the center stage and bring it under the spotlight and perhaps sensitize the insolvency professionals and others to pay more attention to this subject, because we all believe that its importance and significance in the insolvency framework is continuing to be undermined. It has a very important role. It's just not filing an action for clawback. It has much greater value for those who are affected by these avoidance transactions and who might benefit from the clawback. And I think it is with this intent we thought that it would be a good idea to do a series of webinars on this topic. We had one 2 days back where we had UK experts from US sharing their experience, and today we are talking about the UK experience. And we have an excellent panel in SONYA and Ben, of course, Dr. SAHOO himself. Before I go to the panel, and I would request Dr. SAHOO, since we have the benefit of his presence, to share his thoughts on this topic, the importance of this topic, and why it was decided between IBBI and IIII to pick this as the subject for these 2 webinars. Over to you, Dr. SAHOO. Dr. SAHOO, you're on mute. You'll have to unmute. Yes.
Thank you, Mr. Batra. I am extremely grateful to International Insolvency Institute for helping us to build the capacity of insolvency profession in India on dealing with avoidance transactions. It has been 5 years since the code was enacted, and still it seems we have just started. Like any other economic law, the code has evolved, developed deeper and stronger roots, and yielded some great outcomes. It has established the supremacy of market to resolve insolvency, reinforced the rule of law in the space of insolvency, from providing freedom of exit to rescuing companies in financial stress to helping creditors realize their dues, and most importantly, redefining debtor-creditor relationship. The list of achievements of the code is quite a long one. However, avoidance transactions, as rightly mentioned by Mr. Batra, have not gained much traction. Not much jurisprudence has developed in this area, but time has come we cannot avoid dealing with avoidance transactions anymore. It is because it is key to the primary objective of the code, that is resolving stress. Avoidance transactions, dealing with them serves the primary objective in many ways. First, the Bankruptcy Law Reforms Committee, which conceptualized the code, had identified two additional sources of additional value in corporate insolvency, other than the assets available with the corporate debtor. These are sale of a business as a going concern or resolution as a going concern, and the recovery of value from avoidance transactions. The code therefore enables the stakeholders to avoid avoidance transactions, that is, undo them and thereby claw back the value lost through such transactions. If transactions are undone, lost value is retrieved, the creditors stand to realize value from avoidance transactions as well as from the existing assets. Higher the value the creditors can realize from the corporate in stress, the higher is the likelihood of resolution of stress by a resolution plan, which is the primary objective of insolvency law in India. Second, the code undoes avoidance transactions and requires the beneficiary of such transactions to disgorge the value, and thereby takes away the incentive to indulge in such transactions. And since such transactions are considered criminal in certain circumstances, particularly when it is fraudulent, in fact, in a few cases, criminal actions have been initiated in India. It disincentivizes a potential miscreant. These incentives and disincentives are likely to ensure that there is no vulnerable transaction, and in such a case, value will reside with the company, and consequently the possibility of a company getting in stress is much less. In this sense, the code prevents stress, which is another key objective. Third, interesting provision is section 66(2) that makes directors liable for the loss to the creditors that arise during the twilight period. The twilight period begins from the time when a director knew or ought to have known that there is no reasonable prospect of avoiding the commencement of resolution process till the company actually enters into this process. During this period, the director has an additional responsibility to exercise due diligence to minimize the potential loss to the creditors, and he is liable to make good such loss. This incentivizes the corporate as well as its promoters and managers to seek resolution in early days of stress when the possibility of a resolution is higher. Generally, when an avoidance transaction is avoided, the underlying property or interest returns from the beneficiary to the corporate debtor. Section 66(2) is however different. It provides recourse against the director who made the transaction and not the beneficiary. The director is required to make good the loss even if he has not benefited anything. This provision, to my mind, has been rarely used. If it is used, no company would resist initiation of corporate insolvency process, and then in the process, the admission will be much faster. I would request my IP friends to assess the loss to creditors in twilight period and file applications under section 66(2). This will take away the entire incentive of the promoters to resist admission and enable commencement of a resolution process when chances of resolution are very high, and this will be one of the big contributions of insolvency profession for these reforms. In view of the gains from vulnerable transactions, the law empowers the adjudicating authority to do any transaction, to undo any such transaction. It undoes these transactions based on an application of an IP, either as a resolution professional or liquidator. Section 47 of the code, inter alia, provides that the adjudicating authorities shall require the IBBI to initiate a disciplinary action against the RP or liquidator where he has not reported undervalued transactions to the A. This is in respect of undervalued transactions only, but IBBI, if reported to IBBI or comes across any such instance, would be initiating disciplinary action for not reporting any kind of the avoidance transactions. And to ensure that an IP discharges his responsibility, CIRP regulations require an RP to form an opinion whether the corporate debtor has been subjected to any avoidance transaction on or before 75th day of the commencement date, make a determination before 115th day of the insolvency commencement date, and apply to the adjudicating authority before 130th day of the insolvency commencement date. In a landmark judgment in the matter of Anuj Jain versus Axis Bank Limited, the Supreme Court has clarified the duties and responsibilities of the resolution professional in respect of avoidance transactions. It held that the RP shall sift through all transactions. I repeat, all transactions. The RP has to sift through all transactions relating to property interest of the CD backwards from the insolvency commencement date and up to the preceding 2 years. And in the words of the Supreme Court, after carrying out volumetric and gravimetric analysis of the transactions, he must apply to the adjudicating authority for necessary orders. There are instances where some IPs do not discharge this responsibility. In a recent matter of Suraj Fabrics Industries Limited, recently decided by the adjudicating authority, in this matter, the RP filed the application on 389th day of the CIRP. He filed after he has filed the application for approval of resolution plan. He did not make any determination whether relied on a forensic auditor's report, did not give any independent reasons for determination. So the adjudicating authority, while dismissing the application, observed that the feeling is inescapable that the RP has filed the application under section 43, read with section 44, only to avoid adverse scrutiny on the part of the IBBI and not with any real intent to pursue the alleged preferential transactions to a logical end. So there have been a few such instances, and IBBI is constrained and has been constrained to take disciplinary actions against the IPs. So the insolvency reforms, particularly clawback of value lost in avoidance transaction, solely rests on the shoulders of IP. IBBI would not like half-hearted or tick-box approach to this. It would not like an IP taking shelter under non-cooperation of the ex-promoters, ex-management of the CD, or its statutory auditors, or even the committee of creditors to hide its own inefficiency or hesitancy. An IP, to my mind, who back value lost in avoidance transaction at a premium in the market, and to neglect this aspect, market should punish them in addition to punishment by the IBBI and the IPA. There are, however, certain gray areas. These will be sorted out in course of time. There are not many case laws. In a recent matter, in the Venus Recruiters matter, the Honorable High Court inter alia held that the avoidance applications do not survive beyond the conclusion of CIRP. The adjudicating authority has no jurisdiction to entertain and decide these matters in respect of a CD which is under a new management after approval of the resolution plan. And the resolution professional cannot continue to act on behalf of the CD under the title of a former RP once the resolution plan is approved and new management has taken over. This has cast a shadow on the pending applications where resolution plans have been approved or where the CD has proceeded. There are many such issues. And based on my previous experience, I can cite a few, raise a few such issues. Some of them are: how do we motivate an IP to discharge his duties in respect of avoidance transactions? How does IBBI monitor an IP if he discharges his duty in this regard appropriately? How does IBBI know that a company had been subject to avoidance transaction yet the IP did not do its job? Further, must an IP determine avoidance transaction himself, or is he supposed to hire some other professional? Who is that professional competent to help him? Are the reports submitted by such a professional conclusive? What actions can be taken against such professional who submits inconclusive, evasive, or wrong reports? Next question is: we know the law casts exclusive duty on the IP to deal with avoidance transactions. However, at times he is prevented by the COC from determining such transactions. Either COC refuses to provide resources for the same, or it is interested to avoid possible action against some of its members. There is always non-cooperation of promoters, threats of criminal actions. In fact, criminal actions have been initiated against IPs. So how do you protect IPs in such situations so that they are not discouraged to file avoidance transactions? Are applications for vulnerable transactions disposed of along with or before approval of resolution plans in UK? If not disposed of, who pursues these applications post-resolution or liquidation? Who would be beneficiary of the value underlying these transactions? While the applications are yet to be disposed of, can the value underlying these transactions be sold? Can there be a market for securitization or trading in avoidance transaction, and how to develop such a market? And my last question would be: how successful is UK in this regard? How many applications are filed in a year? How much value is realized through these actions in a year? What is the average time taken for disposal of such applications in the UK? I'm sure we will have answer to these and many more in respect of avoidance transactions from Mr. Ben Jones, Ms. SONYA GRAAF, and Mr. BATRA. I thank them for agreeing to guide us on this important dimension of insolvency regime, and I look forward to hearing them. Thank you.
Thank you so much, Dr. SAHOO. You raised some very, very valuable issues, which I'm sure Ben and Sonia were listening to in terms of how to address some of these issues. There are two more issues that I would like to sort of amplify before we get into the discussion, and actually they sort of stem out from what Dr. SAHOO stated. One is, and I think that's where the real challenge comes, that most of the insolvency professionals, well, of course, besides the general reluctance and the hesitation of the half-hearted and tick box approach that Dr. SAHOO referred to, also don't appreciate the importance of the avoidance actions in terms of enhancing and maximizing the value for the creditors, and which is what the objective of the insolvency code is. And I think that's where probably we need some capacity building. The second, I think they also don't really sometimes think that this is their priority area of function, because they have enough on their hands. They have to, stabilize the business. They have to manage the resolution plan process. that's where the focus should be, and therefore they don't see really why they should be putting this on the top of the agenda and spending time or effort, resources, and energy on that, not realizing that this is an important part of the resolution plan process. Now, and also Dr. Sahu mentioned about, sometimes there being a pushback from the promoters, and that's very true. And this is something which I can share as a very brief story before I come to you, Ben. Sorry, from last evening. A very last evening, where one of the clients that we are advising on, a resolution professional, he has filed an avoidance transaction against one of the joint venture partners, and of course the promoters, in respect of a huge piece of land that was allowed to be let go in the resolution plan process. It's a real estate development project, and those developers, which are the joint venture partners, actually came with a huge number of people yesterday at the premises wanting to take over the possession from the resolution professional, insolvency professionals, entered the premises forcefully and threatened that they would take over the possession and blah, blah, blah. And ultimately, we had to do a lot of firefighting, had to speak to the police commissioner of the state of Haryana, and ultimately got a brick wall made overnight so that they cannot enter because there was no gate otherwise there, which could be locked. It was an open access. Had to build a wall overnight, create a lock and key system, got a police commissioner to make sure that he speaks to the concerned police officer in the area so that no trouble is caused, and we were able to avoid trouble till this afternoon. Although, of course, we're going to court for protection, but this is the kind of violent reaction at times you face from people. And if the insolvency professional is not resourceful enough and is not being guided, by the right kind of advisors, it can really cause a lot of problem for him. We all know that the threats that come from these people. Anyways, what I was hoping to do was, Sonia, maybe start with you and then go over to Ben. And I would request both of you, when you take your turn, to please introduce yourself and your firm briefly before you make comments and observations. But the way I was thinking we could start was, perhaps you could introduce the UK framework a little bit to begin with for the benefit of our listeners, in particular because, although, of course, we are a credit control regime, we have sort of borrowed very largely from the UK system. But I do know that when it comes to the avoidance transactions, we may not necessarily be replicating how it happens in the UK. There is a huge amount of difference in how you operate and we operate. But at the same point in time, there's a huge learning that can happen at the same point in time from UK. So we need to be a little bit more aware of how it works in UK. And surprisingly, we are a little bit more closer to US, although it's a debtor in possession regime, but because the whole insolvency process sort of has a sanctity of a court, there is a process which is in a way court-driven, or although of course it's not very intrusive in both the countries, but there is a court's oversight. So maybe Sonia, you could start by familiarizing us a little bit about how it works, and also in that process deal with some of the very basic but fundamental aspects, so that we have a context of the discussion in terms of what kind of transactions there are, what are the clawback periods in UK, and who can file and who benefits, some of these very basic questions, which I think will help us set the backdrop for the discussion that will follow. Over to you, Sonia.
Hi, everybody. Very nice to see you. Thank you, Sumant. Thank you, Dr. Sahu, and thanks very much for inviting me. I'm a restructuring partner at AVONHURST in London, and I've been working in the insolvency and restructuring aspects of the law for most of my time as a lawyer in the last 23 years. And AVONHURST is a London-based firm which focuses on providing advice to what we term as sophisticated capital. So primarily creditors in situations, but I also advise boards of directors and insolvency practitioners. And just so that you know, AVONHURST is a rather unusual law firm. It's also a firm that provides advisory services on a political and investigatory basis, and capital introductions. So that's probably enough about me. In terms of just taking the first point, Sumant, you know, the framework that we have in the UK for avoidance actions, I don't think it's going too far to say that it is absolutely deeply embedded in our insolvency law that an insolvency practitioner, once appointed, is required to take stock of the company and its assets and its liabilities. And one very fundamental aspect of that task is to find out how he can maximize the assets of the estate for the benefit of the unsecured creditors as a whole. And a fundamental aspect of that task falls to him in terms of analyzing and investigating and making inquiries of people to find out whether or not there are any antecedent transactions that he needs to pursue. And it's very clearly laid out in our Insolvency Act what these antecedent actions are, and maybe Ben can go through those a little bit in more detail, because I'm just going to lay out the broad framework. But the Insolvency Act specifies what the actions are and the very precise terms of the action, and those actions are supplemented by other aspects of the law, such as our Statement of Insolvency practice rules. And those practice rules set out in great detail what is expected of the insolvency practitioner in terms of how he needs to go about conducting himself when he investigates these potential antecedent or avoidance actions. And I think it's very clear to me that the insolvency practitioners take that aspect of their job incredibly seriously, and they spend a lot of time and a lot of money investigating on a forensic basis and on a inquiry basis, an actual active inquiry basis. And it's written in the practice directions that he must make inquiries of creditors, of the banks, of the accountants, of the directors, and anyone else involved in the operation of the company within the last 2 years to ascertain whether or not there is any mileage, any merit in filing action Dr. SAHOO and SUMANT, it seems to me that the task may not necessarily be precisely the same as it is for an Indian IP. So an insolvency practitioner appointed in an English insolvency will either be an administrator or a liquidator, and the task of those two insolvency practitioners will differ depending on whether he's an administrator or a liquidator. The task of a liquidator is quite simple. It's to monetize the assets of the company so that he can pay the creditors, the secured creditors and the unsecured creditors, and if with a bit of luck, if there's any money left over, the shareholders. So clearly there, the task is simply to liquidate the assets, as the name of the liquidator suggests. So I think there, the task to investigate avoidance actions is front and center of his role. Now, contrast that to the role of an administrator, and the role of an administrator is a little bit more complex, because a company cannot go into administration unless one of the three goals of administration can be met. And there's a hierarchy of those three goals. The first is to endeavour to return the company as a going concern outside of administration. So in other words, sort of revive the company. The second is to, if that is not possible, then to maximise the return for the secured creditors in a better way than could be done if the company was to not go through administration first, but just to go through a liquidation. And then the third one is just to maximise the recoveries for the unsecured creditors in a better way than if it was simply to go into a liquidation. And I think what you notice there is I haven't said anything about a plan. So there's nothing written in the insolvency law about the role of an administrator to endeavour to negotiate a plan with creditors. Now, that's not to say that he can't do that. And there will be circumstances in which it is appropriate for an administrator to see if a plan is on the table. But under English law, the way in which practice has developed is that a plan will be done outside of an insolvency, a formal insolvency process. So it's only really if a plan cannot be agreed prior to a company going into a formal insolvency process that that we have an administration or a liquidation. So a liquidation is the end of the life of the company, and an administration is, well, there's some hope in achieving you know, the restoration of the company. But 9 times out of 10, to be honest, in an administration, we have a pre-pack administration where it's already agreed that there will be a sale of the assets of the company to a third party or a connected party, or it will be a trading administration and then possibly a liquidation thereafter. So what I'm trying to get at is that there's very little tension for the insolvency practitioner in his task. So his task is very often going to be simply to maximize the value for the creditors. And so, you know, as I say, front and center of that is to investigate the antecedent transactions. And it's probably worth saying that antecedent transactions is seen as being a fundamental aspect of the pari passu principle of English law, which is that creditors need to share equally in the pot, and nobody should be preferred. And if somebody has been preferred in the 2-year window, and we can get onto the you know, the time periods in detail later, but if anybody has been preferred, then that needs to be undone so that everybody can share on a pari passu basis. I think that's probably enough for me, although I will just say just one thing before I hand over to Ben to supplement what I've said, is that I don't think that insolvency practitioners see there being a problem in demanding from directors or officers of the company their cooperation. It's written in our Insolvency Act that directors and other connected parties must cooperate with the insolvency practitioner. And if they don't, then their feet will be held to the fire, and they will indeed do so. They lose their powers as officers of the company upon the appointment of the insolvency practitioner. And it becomes beholden on the insolvency practitioner to conduct the affairs of the company for the benefit of the creditors. So I think there's a very clear delineation of roles there upon the, you know, the acts coming down on an insolvency filing.
Well, thank you, Sonia. Before I go to Ben, you know, I just had 2 quick questions for you, Sonia. I mean, as a drop down from what you just said, because I was thinking as you were speaking, and that's something which the listeners may want to know. One is that when a plan is being negotiated outside the formal insolvency process, you said, and invariably that is how it happens in a pre-insolvency stage. If the lenders, the creditors were to be suspicious of any antecedent transactions, anything which they believe requires an investigation, would they still have the ability to ask for an investigation into that because they don't want to lose the value, or would they give it a commercial consideration as a part of the negotiation? That's one question that I had. And the second was that you mentioned about the statement of practice, which we know, of course, is something which plays a very important role in the UK framework. And you did mention that there is an implicit duty to investigate the affairs, and that one would like to believe that you're also supposed to investigate the antecedent transactions. Now, is there any reporting mechanism in the UK where the insolvency professional is required to inform the IPAs that they are licensed by in terms of the transactions in respect of which they have taken actions and what the outcomes of those have been? That actually is more from the point of view to try and understand, as what Dr. SAHOO mentioned, that how does the regulator make sure that the insolvency professionals are being diligent enough and they are pursuing their duties actively, diligently, and sincerely? There are two questions. Sorry.
Okay, so taking the first question, the right to pursue an avoidance action is the right of the insolvency practitioner. So that there are a couple of situations where there are an exception to that, where a creditor who has suffered loss can pursue an avoidance action. But by and large, the very great bulk of the rights to pursue an action is only by the insolvency practitioner. So to answer your question, Sumant, about whether or not the creditors who are negotiating a plan will have the ability to pursue an avoidance action, the answer is no, if that is being done outside of an insolvency process. Now, that's not to say that the actions are ignored. They are often dealt with in the conditions on which the creditors agree a plan. And we've lately been seeing some instances where creditors will actually be told about a potential avoidance action, and they will be asked to waive it, or they will be asked to just acknowledge it and just let it rest there. Ben might want to speak more about that. And in terms of the obligation to investigate, it's actually written there in black and white in quite a lot of detail about the factors that the insolvency practitioner needs to take into account as to the extent to which he must investigate. For example, you know, if there are no funds, if it seems that the merits of pursuing a case are low, then, you know, there's a lot of discretion given to the insolvency practitioner as to the way in which he conducts the investigation. But he does report to the body of creditors. There is a creditor committee that he reports to, and he will take it upon himself, if in doubt, to discuss queries with the creditors. However, the obligation and the way in which it is done falls on his shoulders very squarely. But most IPs will avail themselves of the opportunity to speak to the creditors and get their input, if in doubt. Some IPs also take the opportunity to seek directions of the court if there's a large amount at stake or if circumstances are unclear. Now, the powers that the insolvency practitioner has are very, very broad statutory powers, and the court has been known to say to the insolvency practitioners when they seek directions, look, you have all the powers that you need. You're the guy who is closest to the commercial reality. You go and decide what to do. I'm not going to tell you what to do. So that the court tries to limit their involvement in terms of very legal questions. So it's completely different to a US very much court-driven insolvency process. Our insolvency process is very much done away from the court. Court process is limited to approaches by the insolvency practitioner to the court to ask very precise questions. In terms of the role of the regulator, yes, an IP is regulated by his regulator, and you know, it has a duty to report to it. But I'm not aware of them being concerned about you know, the regulatory fire, if you like. Perhaps Ben's got some more experience of this than I do. But in my experience, the IPs are very mindful of just following their obligations.
Well, thank you so much, Sonia, because I mean, an Indian system is actually quite similar to what you just mentioned. That is considered to be entirely the responsibility of the insolvency professional. It is his judgment which matters, and he can't rely on the court. He doesn't even need to take the approval of the committee of creditors. He can consult, he can inform, and any which ways he needs their support to get their costs approved for filing, pursuing, appointing somebody to assist in the investigation. To that extent, yes, there can be engagement with the committee of creditors, but there is no obligation to seek their approval, and nor does the Indian law contemplate that they go to the bankruptcy court to seek any approval. It's entirely their obligation, and they're expected to do their job well. And also, you know, in terms of the regulatory framework, they are slightly different in India, because in the Indian market isn't really as mature as UK market is, and therefore there is expected to be, as a new regime, expected to be a little bit more tighter, you know, kind of a regulatory oversight in order to make sure that this area is not neglected, and there is more diligent follow-up by the insolvency professionals of this area. And of course, as the market develops in years to come, where there's this confidence by the regulator, as I understand, or the oversight body, that, you know, things are moving in their own direction, obviously, you know, the oversight also gets adjusted accordingly, isn't it? That's how you work as you mature. Now, Ben, I'm sorry to keep you waiting that long, but I think some of these questions were very important, and I know I'm also looking at my screen where these questions keep popping up from the audience, and I'm just sort of also picking them up on the way. So, you know, you were obviously listening to Sonia, and that, you know, there was a few things which is said, you know, leaving it for you to cover, and you are, you know, the gray areas. So happy to hear your views.
No, thank you, and thank you, Dr. SAHOO and SUMANT, for inviting me as well. It's a real pleasure to speak with on this subject. And just a little background on me. So I'm a partner at a law firm called SIMMONS & SIMMONS. Like Sonia, I'm based in London. SIMMONS is an international law firm with offices around the world. Despite my greying hair, I'm like Sonia, a youngster. About 20 years experience in restructuring and insolvency, working sort of primarily in London, but also cross-border. So I mean, it's interesting, because I think I particularly found Dr. SAHOO's question or point around, you know, how do you motivate an insolvency practitioner to do this work, and how do you make sure that they're actually doing it, and because I think, as Sonia's alluded to in her response, it's not really that's not an issue that we encounter. And I think partly it's because, as Sonia says, there's a very clear regime through the regulation and the Insolvency Act, which effectively obliges the insolvency practitioner to do this. And, you know, there are mandatory reports which the office holders have to file around the director's behaviour. But also, I think, just to add to Sonia's answers, I also think that there's always what keeps these processes honest, because we do have, you know, an issue, or at least there's a perception in the UK market of transactions occurring where you know, debtors and directors sell companies to themselves, sell their businesses back to themselves, and abandon liabilities. So there is a concern around, you know, the transparency of this. And actually, one element of what I think keeps things honest is creditors being active and taking an active role themselves. So, you know, it would be creditors bringing facts to the insolvency practitioner. I'm actually involved in a case right now where, you know, there may be some fraud. Who knows? It's certainly too early to say, but you know, the creditors are lining up to talk to the office holder because they know that as a result of the fraud, they're not going to get very much of their money back. So they're bringing facts to the office holder, and if the office holder doesn't take action, you know, they will then be writing to the regulator. And also, you know, the strongest stick that creditors have is that they can claim that the insolvency practitioner has unfairly harmed their interests by not pursuing a claim. Not an easy claim to bring, but certainly it's the kind of thing that any insolvency practitioner faced with would be very, very concerned about, because it's you know, it goes to their integrity and also their license. So yeah, I just wanted to add that to expand on what Sonia said, but yeah, completely agree with her responses. And it may the other thought that occurred to me is we also have and I think this is also worth bearing in mind, particularly as I know, given the you know, how recent many of these insolvency concepts were baked into Indian law, is obviously you know, our insolvency legislation goes back hundreds of years, but also we were regarded as a pro-creditor territory, which really goes back to when we used to lock up bankrupts for going bankrupt, and there were criminal consequences. And while you know, we're now a far more balanced jurisdiction, I think many of those changes have happened during the course of Sonia's and my career, and which is very, very recent because we're both incredibly young.
Oh, thank you so much. I mean, you know, Ben, that was very useful. There were two takeaways immediately for me. One, you know, I think the point that you made, that the creditors would be the aggrieved parties if the IPs were not to be doing their job well on filing in avoidance actions, because they are the ones who can say that they've been put to harm because of that inaction, because they are expecting maximization, and there is the neglect and duty of by the insolvency professional. They are the aggrieved parties, and they could pursue a complaint. And I think that happens in India as well, I would say. And the other point that you made, I think, which is very interesting, is also about the report of directors' behavior. I think that's a good point as well, because you know, it's the avoidance in the whole if you were to look at the four corners of the avoidance transaction, the cooperation from the directors in the offices is a very important part. Past directors are those that may be under suspension, and if there was a reporting about how their behavior has been in respect of the avoidance transactions, that also would reflect on them, because they may still be holding their office somewhere else, you know, during this period. So that's a good data to collect, you know, from that point of view. I think that's a very interesting thought, which I don't think is something which is being pursued in India at the moment, to see how we can plug that into the larger game. You know, so again, you know, Ben, I have a couple of questions from you. I mean, we know that, you know, the avoidance transactions are almost the same in discussion as you have in the Indian law, because, you know, our even Companies Act had been what, you know, was the UK Companies Act in a way. But what I wanted to understand from you a little bit was that who meets the cost of these actions? You know, I'm sure there's sometimes very heavy cost involved, and as Sonia also mentioned, that, you know, sometimes it is expected of the insolvency professional that whatever it takes to get to the bottom of the things, he has to do it, and of course it might involve, you know, hiring experts, including advisors. who does really meet this cost in that sense? And the second is that who would benefit from the proceeds of such actions were they to succeed?
Shall I take this one, Ben? I think, yeah, okay.
Yeah,
So, yeah, the short answer to that question, Sumant, is that the estate pays for it. And not only do they pay for the costs, but the estate also needs to pay for the reasonable fees of the insolvency practitioner's time for, for the trouble of doing it. And those fees usually come out at the top of the waterfall as what we call an expense of the administration. And who benefits from any recoveries made? It's the unsecured creditors. So that's, to Ben's point, it's absolutely for the benefit of the unsecured creditors that this is done. And that's why they take a very active interest in these actions being pursued appropriately. I think it's probably worthwhile saying in this context that pursuing an avoidance action is quite an undertaking, because it cannot be done summarily in court. It's not a summary judgment. It's a full-blown trial of the issues, because you're potentially undoing a transaction that, it's possible that an innocent third party entered into for value, and that needs to be flushed out. And I think Ben's going to touch on the defences and so on to an action. But it's quite an involved process, which can take days in court.
Well, I'm glad that you mentioned, touched upon this issue of the complexities involved and the time that it could potentially take, because I was meaning to actually shift gears any which ways and ask you about this. But before I frame my question, I just want to give you the context for that, although Dr. SAHOO touched upon this very briefly. He referred to a recent decision of one of the Indian high courts, which has held that an avoidance action is coterminous with the insolvency proceedings. If a plan is approved by the bankruptcy court or is not approved and the company sort of comes out of the resolution, then any avoidance proceeding that would be pending on that day, if not taken to its logical conclusion, would die its own death. And they, interpreting the code, the high courts held that the bankruptcy courts becomes functus officio and would have no jurisdiction to pursue the avoidance application if the resolution proceedings are no longer pending before it. And they also held that even the insolvency professional will cease to have the authority to pursue those actions that have been filed if they are not concluded by that time. Now, this has obviously set the cat amongst the pigeons, because, invariably, it's like chicken or egg situation, because the law requires you to investigate. Investigation could take a lot of time. By the time you file the proceeding, you actually would have reached a stage where the resolution plan may already also be ready and approved by the lenders and filed before the bankruptcy court for approval. And therefore, the bankruptcy court would have not had the opportunity to even open the file, or in some cases, even if it was filed on a slightly earlier occasion, because of the complexities involved and the parties or the number of parties involved, it may not have had the opportunity to make much progress on that. Now, how do you expect to reconcile the two? I mean, I have always understood that these are two independent proceedings, even though they may stem out of an insolvency process. But once the insolvency process comes to an end as a part of the resolution and no liquidation is ongoing, you can't say that, oh my God, you have to close the file for this as well. I don't think that's the intent of the law, although that judgment is an appeal. We'll know what will happen in that eventually. But my question to you more specifically was that even in your case, it would be in the liquidation proceedings mostly. But would they go their own independent route, or would they be sort of so deeply linked with the liquidation that you won't be able to separate them at all? I mean, how does the UK system and courts approach this?
I can see the quandary for the Indian situation, and it does seem inconsistent with the goal that an avoidance action seeks to achieve. And you know, I was not aware of that being a tension in the Indian law, but it seems to me that a possible solution to the problem for India could be that that the plan perhaps needs to be done in a timely basis, because the clock is running. You know, the insolvency practitioner needs to get on with the job that he's tasked to do, and one of those jobs is to negotiate the plan. And meantime, money is running out, so you know he needs to get funding to run the company and so on. So I would have thought that a pragmatic solution could be to agree the plan and then be able to run the avoidance actions at the same time, but let them run their course after the plan has been agreed. But then to give the benefit of any proceeds of the avoidance action to the creditors in proportion to the plan terms. That just seems an obvious solution to me. In terms of the UK system, we don't have that problem most of the time, because as I mentioned, we don't have, most of the time, we don't have a plan in the context of the insolvency process. So the, you know, the officers run the avoidance action during the proceedings being extant, and the proceedings will not be closed until those avoidance actions are resolved. In terms of distributions to the creditors, that doesn't necessarily mean that no distribution can be made until the resolution of the avoidance action. There are ways in which a proportion of a distribution can be made, and then, you know, depending on the resolution of the action, that the rest of the distributions can then be made. I know in Lehman Brothers, there were several distributions made to creditors during the lifetime of the administration, and that the court needed to be involved in authorizing those distributions, but nevertheless it is quite possible. Ben, did you want to add anything to that?
No, I mean, I'd agree with your suggestion, Sonia. I mean, it's an interesting situation, isn't it? Because you could have I think Sonia's alluded to this before. You know, you can have well, that's very unusual. You can have a scenario where a plan or a scheme, as we also know, can be proposed within the insolvency proceedings, but generally it's used as what we describe as an out of court restructuring process to avoid formal insolvency proceedings. But if it was being done within the insolvency proceedings, there's a question mark over whether a creditor or the debtor might say, well, look, we want the plan to deal with, or the scheme to deal with, these transactions, and would the administrator or liquidator agree to effectively settle them as part of this? And I think the answer to that is only where they've fully diligenced the position and they are comfortable doing it, and then they would do it, but it would be subject to the approval of the creditors. Otherwise, it's as Sonia says, it's something that would just be undertaken throughout the course of the liquidation. And the advantage of a liquidation is there's no kind of ending to it. Our administration procedures are designed to run for an initial 12-month period, and then they can be extended, whereas a liquidation can continue for many, many years. But certainly agree with Sonia that we do see many of the larger insolvencies where there are pieces of litigation, and it's always litigation, where there's some very long time horizon before they're settled, and then the administrators, under pressure naturally from creditors, will look to set aside a provision for the costs of that litigation, which will obviously be very conservative, and then release to creditors what they can of the balance of what they've collected in the process.
Yes, I mean, just to share with you the way sort of the market in India has found a solution around this is, although this judgment is a very recent judgment, but even over the last 3.5 years, the way the market has found a solution to this is that when it comes to a company getting into liquidation because the resolution was found, obviously the avoidance application can be pursued by the liquidator from where it was left by the resolution professional. And of course, the liquidator would have an independent right to investigate further if the resolution professional did not do his duty well, or if he's able to spot something else in addition to what the resolution professional did spot or failed to spot. So that's fairly simple. But in the case of resolution plans, the lenders don't want to delay the approval of the plan just because the avoidance is not getting decided. They're quite happy to delink it as long as the fate of the avoidance application as an outcome of that is clearly articulated in the plan and is very clearly understood. One, in terms of who will pursue it, who will meet the cost, and who will benefit from the proceeds or actions. And invariably, the lenders would provide that it will be a pass through to the lenders, and the debtor or the new management will have no right on that. And they would invariably also ask the insolvency professional who was serving as a resolution professional to pursue those applications in the capacity of an authorized representative, and not as an office holder, but becoming, by way of a contract, now authorized to pursue those, which argument the High Court has not really accepted. But I would say that I read the judgment to be otherwise. I think that the High Court has recognized that, right? Because anybody can be authorized by contractually to pursue, right? Even if I cease to hold the office, I still can be authorized by the lenders by way of a contract to pursue those. But anyways, we'll get some clarity on that as we go forward. But the other thing which I also wanted to bring to your attention was that you mentioned that the beneficiaries of the proceeds are unsecured creditors. We heard the same from our US counterparts 2 days ago. But in the Indian context, unfortunately, it doesn't really work that way, because here the Committee of Creditors, as we were discussing briefly when we were having a preparatory call, that the Committee of Creditors in India is comprised of the financial creditors, which may include some unsecured creditors also, but they don't include the trade creditors, right? Now, these secured creditors are the unsecured creditors who are financial creditors, primarily banks and financial institutions, tend to negotiate the plan, and therefore they provide in the plan that the money will come to them and it won't go to anybody else, because they're the ones who basically sign off the plan. So it's a bit different. Even though they may be secured, they still want to benefit. And I think that's because as a policy choice in a way, because that's how the Indian market works. So the funding is largely coming from the banks in India. They provide the credit. The credit market is designed in such a way in India. And we don't really have as much of operational creditors or the trade creditors funding. I mean, of course, they do in their own way in terms of the operations. All right, may I just, we have a lot of questions coming in. And I just want to sort of, as a part of a discussion, also include those I have been doing as we've been speaking. One of the other things which I think which fell from some of my colleagues in the chat box and the Q&A is we all understand that this is time consuming and it's costly. So do people in UK market against whom action is proposed, when they put a notice, do they sit on the negotiation table and try to resolve this by mediation or in some other way so that litigation can be prevented, avoided? Is that something which is prevalent in the UK market? I think that would be a good thing to know from you, if you can throw some light. Maybe Ben, you could respond.
Yeah, I'm happy to. And look, I think, so in my experience, it's actually quite rare for these cases ever to get to court. For exactly that reason, as you know, Sonia outlined, these are not cases that can be dealt on a summary basis. So when they go, they're expensive, lengthy trials, and I think the sort of we don't have a defence bar, but the sort of those who commonly defend individuals against these actions, they know that the office holder will have limited resources, and therefore you find the tactic of delay and limited engagement being used, particularly if the defendant is not based in the UK, and so you do find that many of these are settled out of court, either through mediation or simply just a final exchange of correspondence, because what we haven't done the boring thing of taking you through the UK regime, but that whilst we have quite an extensive regime both set out in statute and in common law, there are elements of that are common to each of them which are quite difficult to prove when it comes down to it. So, for example, the look back period is obviously very simple because it's a factual question. Did X happen within the last 6 months, 12 months, or 2 years? But the more challenging thing is that it's often a requirement of pretty much all of these that at the time of or as a result of the transaction, the company was insolvent. And insolvency in the UK is a very, very amorphous concept. And obviously, if you're looking back on a company, can you point to many companies today and say they're solvent or insolvent, particularly given where we are with the pandemic? Well, it's challenging to say the least. Can you say that 2 years ago a company was solvent or insolvent, where the company most likely has terrible record keeping? It's really open to debate. So you do often find that actually you get very bogged down in some of these difficult factual points. And so, as I was saying, yeah, it's often the case that they don't go to court and they are settled. And then finally, there are, again, in my experience, and I'd be interested to hear what Sonya's experience is on this. With my experience is that when you go into these situations and you look at them, it's very, very obvious the ones that you're going to win on, because it will be, for example, a construction company, and one of the directors' brothers will be the supplier of cement, and you can look at the accounts and they were repaid in full the week before it went into an insolvency process, and everyone else is sitting there not getting any money. And that's like the low-hanging fruit. The more complex ones, where you have the bigger challenge. And so there are sort of easy wins and not so easy wins.
Yeah. Well, thank you for that, Ben. And I've been picking questions, and this is something which I'm addressing the listeners and the participants. That I've been picking your questions, and I've been putting them in my own way. So pardon me if I'm not, taking names of people whose questions that I'm putting or including in the conversation. Pardon me for that. There's so many coming in. I'm just sort of quickly reading them and taking a gist of that and putting the question in. And this one actually is from Ayushi, which actually sort of dovetails into which we were just discussing. Of course, getting an order on an avoidance action is one thing, and enforcing it another is absolutely another one. And in the UK concept, I do believe that if there is someone who suffers a judgment, although there is a right to appeal, but you won't be able to delay it beyond the point in terms of paying up if you need to pay up unless the judgment is stayed. In India, it can often take quite a lot in terms of time and effort to get these people to pay. Although of course there are a couple of layers of appeals, right? So does that also play a role? Because people know that if they suffer an order, they will have to pay. They won't be able to delay it, kick the can down the lane for too long. Yeah. Well,
no, you're right. How long is this piece of string, our right to appeal these judgments? And yes, if the losing party chooses to appeal, then and they have the right to appeal, then that can obviously delay things. But a couple of mitigating points there. We do have the costs award rule here, and the losing party usually has to bear the brunt of the bulk of the costs. So not only do they have to pay their own costs, but they have to pay the bulk of the winning party's costs as well. So that's a bit of a deterrent to just continue kicking the can down the road if they think that their case is not meritorious. And then the other point, I suppose, is to avoid all of this, perhaps just do a quick and dirty valuation of the claim and sell the claim. And we have now the benefit of a statutory provision which actually gives the right to the insolvency practitioner to do just that, which is to sell most of these categories of claim. And I think, in real life, I think that's exactly what's done, because we now have an active market for litigation funders, people who want to pursue these things and have the funds to do it and the time, and they that is their purpose for being, is to pursue these litigation claims. Whereas the raison d'etre of an insolvency practitioner is to increase the pool of funds for the benefit of the unsecured creditors, and obviously he can be unfortunate to get involved in these shenanigans, but that's not the purpose of his life. So very often he will be minded to see if there is a market for the claim and to sell it, and the task will be to get the right price for the claim. And so he may take it to market or conduct an auction to do just that.
Well, I mean, this was going to be my next question to you, and I'm so glad that you took it up, because this is something which has perplexed us quite a lot, Sonia, and the Indian experience so far. And our reasons have been slightly different, though. One, that we do have companies in insolvency which have gone through a lot of financial stress, and they don't really have any cash in their pocket. So when the insolvency professional is appointed, he's virtually cash strapped, tripped. There's virtually nothing in the company, and it becomes very difficult for him to perform his function. He's not getting paid. He can't hire advisors. The lenders are not willing to spend good money after bad money, invariably, and certainly on the preferential transactions, they are a very clear. There's a clear visibility of what the outcome is going to be. They don't really see any value in spending too much money in allowing the insolvency profession to hire experts, advisors, and to file those proceedings, which they know could take years, right? Now, yeah, litigation funding would be a fantastic idea there. And I don't know whether we are, as a country, prepared for that at the moment. I know UK, Australia, US, even Europe, Singapore, there have been enough experiments on this. I spent a fair amount of time in my book on talking about it. The only challenge that we are struggling with is that, yes, litigation funding may be for a lot of things, but whether can they be used for an assignment, for assigning an avoidance action? Is that something which can be traded as an asset or something? We haven't really explored. Do you want to expand on that a little bit? Because I think that's something which will be of great interest to people who are listening. And from a policy point of view also, whether this is something which is something which we should look at. And I asked this more particularly because recently the Indian regulator did a paper on liquidation process, because now a lot of companies are going to liquidation. So they were just looking at the regulations a bit carefully. And one of the things that they did put in there, that some of these claims or recoveries, which the liquidator needs to pursue, could be traded. He could do that. Now, but whether they include an avoidance action or not, a potential contingent claim from an avoidance action, is still something which I don't think there is clarity at the policy level also on this, or even at the legal level. So could you just amplify on that point a little bit?
Shall I take this one, Sonia?
Please do, Ben, and then maybe.
Sorry, I was trying to find my unmute button, but go ahead and we can have a dialogue about it.
Cool. Look, and I think I've got former colleagues who've moved into litigation funding. It's a real booming market in the UK, probably catching up with the US. And so we're seeing constant ingenuity in the litigation funding space when it comes to insolvencies. A number of the funders will actually use their own balance sheets to acquire claims that they like the look of. So in terms of the recent legislative changes that Sonia referred to a little while ago, preference claims and transactions that undervalue claims can be assigned by the office holder. And in fact, it kind of goes back to a point that I was talking about earlier in this discussion, which is, you know, keeping the insolvency practitioner honest. So you can look at these assignments of claims as, you know, a quick and easy way for the IP to realize value for an asset where they haven't got the resources themselves to realize them. But equally, if you have, there is actually a number of the cases have been looking at it from the opposite way, which is where an insolvency practitioner is not pursuing a claim, perhaps because there's a perception that they've become a little bit close to a director or management. Say, for example, they're appointed by the directors, and so they get legal advice, and the legal advice is, well, you know, there's a very low prospect of success. So on that basis, they say, we're not taking the action. And actually, creditors have said and successfully argued that that doesn't matter. If they're saying that the claim is worth nothing, then the insolvency practitioner is obliged to sell it for more than nothing. So if a creditor says, you know, I don't care, I'm so cross with the behavior of this director, I really want to go after them because I think I'm really aggrieved, and here's £1, I'll buy this claim from the insolvency practitioner, they're actually duty bound to sell it for that amount. So yeah, I think it's been, I mean, I think it is quite useful, and certainly I think when insolvency practitioners come to examine claims and make a decision about what they're going to do with them, that the menu of options is now broader. So just simply in the past have been, you know, I don't have enough cash to fund the lawyers and to run the exposure of not winning and having to pay the other side's costs, to, you know, can I use one of the new devices, such as conditional fee arrangements or damages-based agreements, or after the event insurance? Is there a funder who's going to be willing to take it on? To, you know, shall I market it and see if I can sell it because there are known funds in the market who will buy these claims for a discount, obviously, and a significant discount, depending on how good they are.
Sonia, would you like to supplement?
No, I agree with what Ben said. In just an interesting point about, you know, the creditors being so cross that they might want to buy a non-meritorious claim for £1 just so that they can have their day in court and just, you know, have a pop at the directors. Yes, that is possible. But there was a case about an administrator being asked to transfer what was referred to as a frivolous claim, just so that the creditor could harass the directors. And there was a lot of discussion about, you know, the duty of the insolvency practitioner to decide whether or not it was actually okay to sell the claim. And I think the court came out and said, well, that there's no imperative on the insolvency practitioner to not assign the claim that has no merit. However, if it is just for frivolous purposes, then they probably shouldn't sell it.
So I think that's very interesting. This is certainly a topic for paper between III and IBBI, or at least III can do for IBBI. And I'm sure colleagues at IBBI are listening to this. I know Dr. SAHOO had to log off to address another seminar which he had at 4 o'clock. But I certainly feel that this is one area which we can add a lot of value on, and we should certainly internally socialize this with III as to how we may want to do this. There have been a lot of questions on the cross-border aspect, and we also discussed, you know, amongst us yesterday that we should touch upon that aspect. In the context of larger enterprises which have cross-border businesses and trading, and even sometimes within the group and outside the group, of course, How does IP deal with cross-border avoidance sanctions? In particular, when you don't have a cross-border law in a UK and US and some of the other, I mean, you have almost nearly 50 countries which have now. But irrespective of that, I mean, how would an insolvency professional deal with cross-border avoidance transaction? I mean, any of you can take it. I mean, Sonia, maybe you can start and then we could go to Ben, or Ben can take it. I'll leave it to you. But...
I'm easy.
Okay.
I'll kick off because
Yeah.
and then you can correct me, because it's actually a really good question to ask, and in the UK I think we're all kind of feeling our way a little around it post Brexit, because one, regardless of your politics around Brexit, I think we can all agree that cross-border insolvency is more complicated as a result of Brexit, because we lost the benefits of our membership of as a member state of the European Insolvency Regulation. And what that usefully did is it did provide a regime within Europe, at least, for antecedent transactions, and so we don't have that anymore. There is a kind of jurisdictional gateway which exists for certain avoidance actions, so transactions defrauding creditors and transactions that undervalue, provided the court is effectively satisfied that there's a real prospect of success and there's a sufficient connection to the jurisdiction. They will make orders permitting office holders to go to proceed against individuals who are or companies that are not within the jurisdiction. But it is challenging, and I think it's challenging for the reasons we were just talking about around enforcement of judgments. Is that inevitably, if you're not in the jurisdiction, you've got another layer of court to go through. So yeah, that's really challenging, and I think we had a bit of a setback as well, which is probably consistent with the line of decisions singularis and so on around cutting the golden thread, which is or not cutting it, but certainly making it a lot thinner, which is there was a recent decision around the use of Section 236, and Section 236 is a really powerful tool for the insolvency office holder, because what it does is it enables them to call directors and those involved in the company and order, effectively get a court order requiring them to answer questions. And we've seen that power being eroded over the last decade or two, and most recently, effectively the position has hardened, solidified, which is that, broadly speaking, it's a power that can't really be exercised out of the jurisdiction. So I don't know, Sonya's been looking at this too, so she'll be able to expand, no doubt, on that case. But that really does curtail the ability for an office holder to gather information before they know whether even a case exists to answer.
Yeah, not a lot to add to what Ben's just said, but it's the practical issue. Whilst the court may consider itself to have technical jurisdiction to provide assistance, they won't exercise their discretion to do it if they're of the view that the forum conveniens is elsewhere, because they're not of the view that there will be any point in granting the order. So it's about submission to jurisdiction as well. If the counterparty is not duty bound to submit to the English jurisdiction, then I think it's going to be difficult for the court to be convinced to exercise its jurisdiction in favor of granting the order.
Yeah, I mean, I wish we could have discussed this a more deeper, because this is something which I'm sure interests our participants quite a lot, but unfortunately we don't have the luxury of time. We've just got 7 minutes left, and I wanted to ask 2-3 more questions very, very quickly, which is coming up in the audience. One, I wanted to sort of ask, these are some very basic questions. I know we had one more topic to discuss with regard to the how do the courts approach in this and some of the jurisprudence, but maybe that's something which we can leave for a later point in time. The jurisprudence is quite well developed, it's very sophisticated, and I'm sure people can Google that, and it's available on the internet. The 2-3 very, very basic questions, because otherwise, some of these people will get upset that I didn't pick those questions, or might get upset at least. One, they wanted to know a very basic thing, what would motivate an insolvency professional to really pick this up and go after it? And I'm going to list a question, then maybe you can take it up. The second is in terms of the cooperation, from the directors. You did mention, Sonia, at the beginning that that there is an obligation, but in real time, in practical terms, how does it really work? Do the directors really cooperate, or is just something on the statute book? The third thing is, some people also want to know that can the liquidator or the professional, insolvency professional who is pursuing these claims appoint experts, the forensic experts or other professionals to assist him? As the third question. And the fourth was also access to records. I mean, he needs to investigate, he needs to have access to records. And how does that work as a challenge? I mean, and maybe you could also just talk about the challenges that an insolvency professional would normally come across while pursuing such actions. Probably all these four are connected in that way, isn't it? Except the motivation part. So maybe, Sonia, you could start, and then we could go to Ben on this.
Well, maybe I could be a little bit cynical in answering the first one. So, what motivates the IP to go after an avoidance action? Well, he does get paid for it. It's the time cost of an administrator or a liquidator that he's paid for. And, quite apart from the fact that he is statutorily bound to do so, he is rewarded for it. So I think that's a sort of a cynical answer. Ben, do you have a less cynical answer?
No, I think that's I'd agree with that. I think it's yeah, I mean, fee coverage is pretty critical, and it would, if it's part of what you're there to do and being paid for it, then it's logical they would do it.
And also, I mean, I think another motivation also probably is that if you get some good results, you get reappointments, you get more and more appointments, you get more and more assignments, and you earn a good reputation for yourself. So that's another motivation, isn't it, at the professional level, in terms of earning a reputation? And
I think that's absolutely right. It's a very competitive market, actually. The UK market for IPs is, I think it's fair to say, quite saturated at the moment. We're going to have a different problem soon when the market turns and we have a lot of insolvencies coming down the pike. But at the moment, I think every IP wants to do the best job possible and pursue every single claim as assertively and potentially aggressively as he's professionally able to do, because he wants the next job. And it's the creditors who appoint him at the end of the day, usually.
Yes, and creditors' motivation always is to appoint an efficient person who will maximize the value by pursuing this. All right, and the other two things, the challenges that people might just face: access to records, cooperation from directors, and blah, blah, blah in real time.
Well, I mean, if the directors don't cooperate and if they don't provide the records, then there will be a court order requiring them to do so. So there's absolutely no mileage in them not cooperating, because they'll be forced to do so.
There's also, we have the disqualification regime. So the report that I mentioned earlier, this report that's submitted by the administrator or liquidator, that's submitted to the, I can't remember what it's called now, government department, BAIS, I think it's called these days. And BAIS will have officers who will look into the conduct of directors, and they will have the ability to fine them, to suspend them from being a director, or to completely ban them from being a director for up to, I think it's 12 or 15 years. And that can have a big influence. In fact, that happened to the chap who was the director at the centre of BHS, which and it's been hugely problematic for him as a result of that.
Oh yes, I mean, I just got 2 minutes by the clock, and I need to take this 2 minutes to thank everybody, because it won't be fair otherwise. I mean, to a large number of participants there, and I first of all have to start by apologizing to them. I see still a huge number of questions which is practically impossible to cover in the short time that we had, but I do hope that we have covered are quite many at the same point in time. But this also certainly underscores the point that we need to be back again soon and do another one. And one with US and one with UK was certainly not enough. There's a huge appetite, which I can see. So we certainly need to be back soon on this. But I have to thank IBBI for partnering with III on this, and inviting III to organize these educational programs for capacity building, and we will continue to do so. And I'm quite sure that this engagement will result into a formidable partnership. We'll hope to see more and more visibility of III in India. We have some more panels lined up in the next few days, and I'm sure we will announce them on the social media very soon. So I also want to thank Justice Kannan Ramesh. He's not here, but he's Justice Kannan Ramesh is a judge of the Supreme Court of Singapore. He's a director on the board of III, and he has played a very important role in pushing us to come together. He's a great ambassador of India, a great well-wisher of India. And therefore, I have to thank him in absentia here. And also, of course, to you, Ben and Sonia, for taking out the time. I really appreciate this, and I think we had a wonderful insight on the topics that we discussed. I also have to thank the III team on this, because all of them have worked very hard on this. Anika, Brandy, Sharon, and everything. And without their support, also we wouldn't have been able to make this happen today. So thank you all. Thank you very much, and thank you, of course, to our participants and those who registered. We had about over 450 registrations, but we had at the peak about 250 attending, which is a great number. And thank you so much, all of you, for being here and proactively participating in this. So thank you again. So we say goodbye.